rules governing this final round. Each team shall be allotted a total of 30 minutes to present their case. The time may be divided between the two speakers at the discretion of the team. An additional 5 minutes will be allotted for the rebuttal and 5 minutes for sub-rebuttal, subject to the discretion of this honorable bench. Further guidelines for the smooth conduct of the proceeding are as follows. Teams shall maintain a strict anonymity and identify themselves only through their allotted team code. The official language of the competition shall be English. Speakers are respectfully requested to confine their argument to the issue raised in their particular memorial. The honorable judges may intervene and pose questions at any stage during the submission. The participants are expected to maintain the utmost courtroom decorum, professionalism and ethics. इंस्ट्रक्शंस कंप्लीट करूँ क्या नहीं करूँ?
35,53,000 का है ना, इतना हम 12 लोग चाहिए। हाँ, वो प्रीमियम नंबर 1 है, बल्कि
फिर स्टार्ट करने के लिए उनको क्या इंस्ट्रक्शन कंप्लीट करूँ क्या? I'll complete with the instructions and the rules, and then shortly we'll start with the proceeding. The official language of the competition shall be English. The speakers are respectfully requested to confine their argument to the issue raised in their particular memorial. The honorable judges can intervene and pose questions at any stage during the submission. Participants are expected to maintain the utmost courtroom decorum, professionalism and ethics throughout the proceeding. All participants must keep the audio and video on at all time of the competition. Failing to do so may lead to disqualification. The researcher shall not address the court but may assist the speakers. We'll shortly start with the proceeding. Honorable bench, sorry for the inconvenience. Due to the technical errors, the teams were not able to join. So we need to repeat the instructions again. TC24 is requested to please the researcher is requested to set her camera. She is not visible properly. TC24 researcher, your camera is blurred. TC23 is requested to please on her screen. एक स्पीकर ने किया, दूसरा वाला कर रहा है। ये अपने उसमें प्रोसेस में आया था। हो गया ना, कर दो सर। If the participants are ready, can we proceed? TC24 to please open their mic and they can say.
Should I begin?
No, there will be a formal introduction and then you can read. 23.
Yes.
TC24 petitioner, TC19 respondent.
I'll repeat the instructions. Before we commence with the proceeding, I would briefly tell you the rules regarding the final rounds. Each team shall be allotted a total of 30 minutes to present their case. The time may be divided between the two speakers at the discretion of the team. The additional 5 minutes will be allotted for rebuttal and 5 minutes for sub-rebuttal, subject to the discretion of this honorable bench. Further guidelines are: the team shall maintain a strict anonymity and identify themselves only by their allotted team codes. The official language will be English. Speakers are respectfully requested to confine their argument to the issue raised in their particular memorial. The honorable judges may intervene and pose question at any stage during the submission. Participants are expected to maintain the utmost courtroom decorum, professionalism and ethic throughout the proceeding. All the participants must keep their audio and video on at all times. Failing to do so may lead to disqualification. The researchers shall not address the court but may assist the speaker. I now request the learned speakers of both the sides to kindly inform the court of the time division.
अल्लाह ताला इन लोगों को भी जजाय कर दे, स्पेशली यूनुस भाई।
Petitioner.
पूरा अकाउंटिंग का काम।
One of the will be taking up 16 minutes and speaker 2 shall be taking 14 minutes.
कर
14 minutes.
Is it at your end or from their end? From their end. You may just insert it to reduce the. From here, I think it's from your end. Voice master company.
Speaker number 1 will be taking 16 minutes and speaker number 2 will be taking
14 minutes.
14 minutes. TC23 respondent.
Speaker number 1 will be speaking for 15 minutes and speaker number 2 will be speaking for 15 minutes as well.
Madam, reduce all the voices.
Yes.
Don't tell them to reduce. You reduce from me.
Sure, sir.
चल रहेंगे, तो आपको थोड़ा सा हम दिखाना चाह रहे हैं कि किस तरीके से और अच्छा हो सकता है काम। ये इंटरेस्ट का कैलकुलेशन है, तो किया था ये। देखो, हम इस कंट्री में रहते हैं।
With this, we shall now proceed with the final round. kindly request the petitioner side to begin with their submission. The court is
लेकिन
in
मैं
session.
इंटरेस्ट
Your
फ्री
time
वाला सिस्टम को इम्प्लीमेंट कर सकता
shall start now.
Excuse me, just before you start,
इसमें अगर वो
actually there's a voice that is coming from behind of somebody.
Slow-
Can you just resolve that? Because it is interrupting in the meeting.
सितंबर 23 में 1,40,000 से स्टार्ट हुआ था लोन डिस्ट्रीब्यूशन और उसका अमाउंट
किसी और ने
कैलकुलेट करते हैं।
तो उसको आप हाँ सबको म्यूट कर दो स्टार्ट
रुपये एक्स्ट्रा। ये सब लोगों का हमारा इज्तिमाई एफर्ट है कि इतने अमाउंट इंटरेस्ट से हमने
TC 24, is your problem resolved now?
बचाया। 1% इसका यही है
TC 24, speaker 1, is your problem resolved
इससे
now?
कैसा स्ट्रेंथन कर सकते। दरअसल ये आप लोगों के सामने रखने के लिए और वो स्कीम और अच्छा कैसा कर सकते या आपके
TC 24, is your problem resolved now?
When the microphone of the main profile is shut, then I'm not hearing. But right now, for instance, I was able to listen.
Yes, after we begin, we are going to mute our devices and then you can speak. Okay?
Perfect.
Oh.
So, should I start?
Yes, please start.
Greetings to the Honorable Bench. I'm Speaker 1 and I appear before this court along with my co-counsel Speaker 2 on behalf of the petitioner. Today, I shall be taking up 16 minutes of the court's time to address the first and the second issues relating to Dr. Paul University, and my co-counsel shall be taking 14 minutes to address the third and the fourth issues relating to Gigi Point Dorabji University, which we shall hear after refer to as JDS. Your Honor, if I may briefly state the facts. State legislatures in the Republic of India are empowered to establish private universities through legislation. Pursuant to this,
और
in the state of
जो
Shastra,
लोग एडेड में हैं उसमें भी इंश्योरेंस वगैरह की अच्छा हो गया तुमने आज बात निकाले। जो लोग एडेड वाले लोग हैं और जो इंश्योरेंस कराना चाहते हैं कितना मंथली कितना है
within this framework, Your Honor, Dr. Paul
साल का 836 रुपये
petitioner in this
इतना अमाउंट में
is a
और कितना
university
इंश्योरेंस
that
है
is
2 लाख 5 लाख।
that is sponsored by the
1.5 lakh।
Categories Minority
तो
Society.
ये
And it
गवर्नमेंट
is
की स्कीम्स है
incorporated under
तो
the
उस टाइप
Shastra
के
Act,
स्कीम्स
which
अवेलेबल
has
है।
challenged the statute
उसको
on
इसमें
the
mix
ground
नहीं करना
that it
चाहते।
fails to safeguard its minority rights under Article 30, Clause 1 of the Constitution of India. If I may just flag, I think the main system is unmuted and therefore I'm able to hear a disturbance in the entire meeting. Thank you so much. Continuing with the submissions, Your Honor, to further the case of the petitioner, the counsel shall be making two key submissions. On the first issue, it is submitted that Dr. Paul University and similarly situated institutions that are private universities sponsored by minorities and established under the State Private Universities Act can claim rights under Article
उसको बुलाया और
30 of
उसको
the
बोला कि भाई
Constitution of India.
तुम अभी
On the
तुम ये
second
स्कीम के
issue,
लिहाज से
the council would like to submit that such institutions can claim minority protection and equal protection at par with other state laws in
ऐसा
recognition
देते
of
क्या
their
देते वो
minority
तुम्हारा
rights.
इंडिविजुअल का मैटर।
Coming to the first issue, Your Honor, to demonstrate that such private universities enjoy rights under Article 13 of the Constitution, it is essential to prove that they are minority education institutions in the first place. Your Honor, the respondents will seek to
यहाँ
ask
numbers
that
लगे हुए हैं,
universities like
लोग
Dr.
कतार
Paul
में।
University have an origin in a legislation as they are statutorily incorporated under a general regulatory framework and they are thus not minority institutions. However, Your Excellencies, since very code in the Constitution bench judgment of Aligarh Muslim University versus Naresh Agrawal has categorically clarified that statutory incorporation does not by itself distinguish minority character. Furthermore, in the cases of St. Stephen's College versus University of Delhi and S.K. Patro versus State of Bihar, it has been categorically held that the wheel of statutory form has to be pierced to identify who are the true founders of the institution. That principle applies with full force here. First, the UGC regulation, specifically regulation number 2.1, defines a private university as one that is established through a state or a central act, but by a sponsoring body. Your Honor, that preposition here is deliberate. Through the act, but by the sponsor. The act, therefore, is only the legal vehicle. Sir, is the originating force. And second, and most fundamentally, Your Honor, if the respondent's logic was to be accepted, that statutory incorporation denies minority character, Your Honor, it would mean that no minority institution that is established under a private universities act would ever claim Article 30 clause 1 protection. And that would be an absurd and a dangerous result. That would be inconsistent with the very purpose of Article 30. Therefore, it is our submission that even if a university like Dr. Paul University is incorporated under a state act, it does not ipso facto mean that it loses its minority character. Your Honor, having established that statutory incorporation is not determined, counsel seeks to draw the attention of the bench to what is determined. Article 30 of the Constitution of India recognizes that institution
करें 50,000 रुपए, लाख रुपए जो भी आप बैंक में रख रहे इंटरेस्ट लेना नहीं है, तो आप ये इंटरेस्ट तो लोगों की हेल्प भी हो जाएगी, लोगों की हेल्प भी हो जाएगी और आपका भी काम हो जाएगा। और देखो ये सब लोगों के गवाही से मैं बोलता हूँ कि आपने जितना पैसा लगाया उतना वापस देने की गारंटी हम लोगों को।
Excuse me, ma'am, there's a lot of disturbance going on right now.
I'm so sorry, I think there's a disturbance that's happening again.
We are getting a person on call talking about paying money, etc. It could be generated and provided to us because it's significantly hampering our ability to speak and focus on the ground.
में 10-12 तारीख को हम डिस्कस करते हैं, तो 12 तारीख से आप 20 कितना 20 दिन का ही पीरियड, तो 10 तारीख तक भी हमारे पास पैसा अवेलेबल है और वो 2-3 तारीख को भी सीनियर की सैलरी होने के बाद पैसा अवेलेबल है। इट इज मैटर, अगर वो ऐसा लगता है तो हम
किसने ज्वाइन किया वो आगे वालों को छोड़ दो ना, निकाल दो ना, ये इन लोग के पास राइट है, मेरे पास नहीं नवी लिंक डायरेक्ट नहीं, ये लिंक शायद किसी के पास भेज नहीं, अरे नहीं स्टार्ट करके चेक करो, अभी चेक करो बोलो स्टार्ट। या
I request TC24 to please look that is the voice still audible. TC 24. अरे आपने तो mute करो. TC 24, is that voice still audible?
Now I think it's gone. Thank you so much. If I may just continue with my submission.
Please continue. I think for last minute we lost you. For last minute we lost you. Can you please repeat what all you said in the last minute?
Indeed, Your Honor. My sincere apologies for that interruption. So, the submission that the Council would like to make was that having established that statutory incorporation of a university is not determinative, the Council wants to draw the attention of the bench to what is determinative for considering an institution to have a minority character. Your Honor, Article 30 of the Constitution of India recognizes institutions which are established and administered by minority institutions. But how do we know that who has established an institution? Your Honor, the question of establishment must be answered through a holistic and fact-sensitive inquiry, focusing on who has made substantial efforts in bringing the institution into existence and who retains a nexus with the administration. Your Honor, this is precisely the approach adopted by this court in Aligarh Muslim University versus Naresh Agarwal. Court moved away from a narrow legalistic inquiry, as in Aziz Pasha versus Union of India, and the relevant question that was asked was, who in substance has brought the institution into being and who continues to shape its character? At this juncture, I would like to draw the attention of the bench to paragraph 13 of the Moot proposition, specifically the second line. If the bench is with me.
Yes, yes.
And if I may read for the benefit of the bench, Dr. Paul University was established under the Shastra Act 2023, which is sponsored by the Catechist Minority Society. Your Honor, according to the respondent submissions, such universities, such as Dr. Paul University, which are sponsored by minority society, should not be considered as minority institutions. But Your Honor, the act of sponsorship has constitutional consequences. This court, in the very case of Haji Muqeet Ali Qureshi versus Malay Sharma, has extensively analyzed the role of the sponsoring body in the establishment of universities. The court noted that a university is in effect established by a sponsor. Your Honor, it is the sponsor who designs the administrative framework. It is the sponsor who arranges the necessary properties, including land and buildings. It is the sponsor, Your Honor, who creates the endowment fund. It is the sponsor who appoints the faculty and plans the curriculum. And only subsequently, after all of this process, does a university seek legal sanction, either through the route of a deemed university under Section 3 of the UGC Act or through a statutory enactment, as is the case in our practice. Your Honor, this is precisely also the model that is enshrined in several state legislations in India, which accept proposals for the establishment of the universities. I would like to cite the examples of the Uttar Pradesh Private Universities Act 2019 and or even the Haryana Private Universities Act. Under both of these acts, the sponsoring body has to comply with certain norms. They have to comply with certain infrastructural requirements. The requirements of creating an endowment fund, having faculty and planning the curriculum. Only after all of that process can they apply for a sanction. Government sanction, it follows, it does not precede. And if we come to the present sanction matrix also, Your Honor, Dr. Paul University was established by a sponsoring body, that is the Catechist Minority Society, a registered society, Your Honor, a public trust, that is the sponsoring body. And it is the society that conceives the educational mission, that assembled the resources. And only after that, they could have initiated the process for establishment under the Shastra Act 2023.
Counsel, just to interrupt you. Counsel, just to interrupt you. Can you please cite one instance where the right to administer and establish the religious, the education institution is threatened by virtue of this act? Can you please cite one instance? In the given case. In the given case, can you please cite at least one instance which threatens Article 30, Clause 1 of the Indian Constitution, as in your case?
Your Honor, in this particular case, The very statute, that is the Shastra Private Universities Act, does not contain any protection for minority institutions. I would like number 30 and the last line of para 30. It says that Shastra Private Universities Act had no provision to protect the right of minority educational institutions as guaranteed under the Constitution of India. And therefore, Your Honor, it is our submission that by conflating minority and non-minority institutions together, by subjecting them to the same regulatory standards, there is a violation of Article 30.
Counsel,
Satisfied the bench.
yes, Counsel. This takes me to the another question in this context. Counsel, it seems that you have not challenged the core aspect of the legislation. What you should be challenging, I think that plot you have lost. 1920 JDU Act was enacted. JDU University was established by virtue of a statute, right? And similar instance has happened in the context of the state governments, state universities which are established, wherein it appears that your challenge
This meeting is being recorded.
It appears that your challenge is not to the very act of legislation, but the challenge is to the provisions of the legislation that is there. So, if you go by the constitution and its administration, when a legislative enactment is there, legislative enactment comes with lot of responsibilities on the part of the government. And it seems that you have accepted that state is competent to make legislation when it comes to the minorities' right to establish educational and manage the administrative affairs of the education. So should you not be questioning the very action of the state to pass this law instead of challenging the act per se? Because the moment act is passed, the state is competent enough, to regulate its helms, its affairs.
Just to clarify, the second submission of the council, the second issue would be pertaining to the act itself. But just as a preliminary inquiry that is made in issue 1, it was the council's submission that to qualify for that protection under Article 30, these institutions must qualify first as minority institutions. And till now, it has been the council's submission that a private university, even if it is only
Council, quick interpretation, quick interference in this regard. Council, under Article 30, Clause 1, a minority education institution is to be established. Initiative has to be taken by the minority institution, minority society itself. Here in the present case, initiative has been taken by the government, by the legislature. So your minority status has gone. And to have, let me complete, and to have a minority education institution, you need to establish a society, you need to establish a public trust, and that society and that public trust will manage the affairs of the education institution. You cannot have a university as established by the government and being monitored or being administered by the minority community.
Your Honor, council would like to different perspective. The submission of the council in this particular case is that
something just give, let us allow us to give an instance of TMA Pi Foundation case that you may introspect or you may ponder upon it.
Your Honor, if I have to look at the TMA Pi Foundation case also, it was said that regulation must be there, but it should not be contrary to the freedoms of the minority. In this particular case also, that is what we are trying to suggest, that even if there can be regulation in the form of setting up of standards and prescribing the minimum requirements for academic curriculum, it cannot be something that is going against the tenets of minority freedom. By not providing minorities autonomy in this particular regard, the statute itself is violating Article 30, would be our submission.
Council, when there is a legislative enactment, state and legislature is answerable to other communities as well. State is answerable to all vulnerable sections of the community as well. So who may have some expectations from the state may have to make arrangement, for example, obligation under RTE Act, Right to Education Act. The state also having some obligation, to see towards the education. The reservation, the kind of reservation scheme, affirmative action to be, implemented in the education institutions. So state may have to take care of these, affirmative actions when it comes to the public institutions. So this falls in the category of public institution and not in the category of religious and linguistic minority education institution. And you are questioning competence of state. You are questioning competence of state. state is competent enough to make laws under list 1 of 7th schedule of Indian Constitution.
It is a submission firstly that since Dr. Paul University in this instance is a private institution, it is firstly not a public institution, and in this particular case, the exemption for not having reservation is not created by the petitioner. It is a consequence of the Constitution itself, because Article 30 of the Constitution of Indus is designed to preserve minority autonomy, even where that may create limited departures from like a general regulatory framework. This court, in several cases, has always maintained a balance that minority institutions may not be considered to be outside the constitutional frameworks. They remain subject to regulatory measures, including academic standards, transparency, and fairness. That, therefore, the concern about reservations is important. That cannot determine the threshold of who gets the minority status. That inquiry must remain anchored in the tests which are laid down, for instance, in Aligarh Muslim University versus Naresh Agarwal. If I may have satisfied the bench.
Do you mean to say that, can you hear?
But I think they're not audible.
Am I audible now?
Yeah.
Do you mean to say that reasonable restrictions, which is the fundamental core of the Constitution, whether that can be replaced by arbitrariness?
Your Honor, it would be a submission that reasonable restrictions cannot be replaced by arbitrariness, but at the same time, the question that we are dealing with at this moment is who gets the minority status under Article 30. Now, Article 30 is not subject to a reasonable restriction with respect to this. Now, as if we look at the functioning of the institution, as Your Honor has pointed out about arbitrariness, the state may set certain standards. I would like to cite a few examples with the permission of the bench. So, for instance, I would like to cite the example of the case of Bihar State Madrasa Education versus Madrasa Hanfiya Arabic College. In that case, the court said that regulation is permissible, but where it is infringing the minority's freedom, that should not be considered. In that particular case, the state had empowered a board to dissolve the managing committees of madrasas for any sort of non-compliance. The court said that while regulation of academic standards is permissible, the dissolution of minority management is not permissible. Similarly, even in the case of St. Xavier's College versus State of Gujarat, the state had sought to impose its own authority in the governing body of the minority institution. The court struck it down because they said that while there may be overall oversight of the educational efficiency, there cannot be arbitrariness with respect to that. But this placement of institutional control away from the minority is not permissible. And therefore, if I may have satisfied the bench with respect that way.
Counsel, is it necessary to have reasonable restrictions or limitations on a fundamental right in that article itself? So, so no mention of any reasonable restriction under Article 30, Clause 1 does not mean that it is without any limitation. Does that mean it is without any limitation?
Of course, it is our submission that Article 30 would come with certain limitations which are implied. We have to look at Part 3 as a whole and understand that fundamental rights are interrelated. And therefore, if a right is infringing upon somebody else's right, then in that particular case, obviously Article 30 would come with certain limitations. But if we look at the judgment of Aligarh Muslim University versus Naresh Agarwal, in that case also, this argument had been advanced by the state that if we consider Aligarh Muslim University as a minority institution, there would not be any possibility of affirmative action there. The Supreme Court rejected that. They suggested that Article 30's threshold determination of which institute gets to be a minority institute does not consider all of these restrictions, does not consider all of these, and rather than that, the test is who has substantially put in effort to establish that particular institution.
Counsel, a judgment of Supreme Court is binding on the Supreme Court in any other context?
Your Honor, if the principle of law or the principal situation is the same, then in that case, the doctrine of stare decisis would apply and there would be no scope for inconsistency.
What about counsel changing notions of society and changing notions of time in addition to the constant legal principles which are very much there? If I make you example of, the currently the Right to Education Act, which is otherwise not applicable to religious and linguistic minority institutions. Now the discussion has started, in the legal fraternity to extend the protection of this law even to the minority education institutions. So on a similar note, tomorrow discussion may start on the notion of affirmative action being considered for being made applicable to the minority educational institutions. So does this precludes this honorable court, this court, to discuss matter from the point of view of the principles of secularism, Article 15, Clause 1, Article 14, and then other fundamental rights of this constitution?
Your Honor, if you may just clarify the question that is there.
Does your argument, or does this limitation which you have put forth by virtue of the Aligarh Muslim University case, does it preclude this court from not, venturing in the new arena of the constitutional life or the Constitution of India? Because Constitution is a living document. It changes with the time, and adaptability has to be there. So on the similar lines of Right to Education Act, can affirmative action be still considered in future to be made applicable to the minority education institutions? And thereby the earlier judgments may not binding on the present court. And of course we can see, how there has been variation. Earlier Supreme Court did accept the kind of amendment which after Constitution, JDU Amendment Act 1951, which was there, which was confirmed and which was approved by the Supreme Court in 1967 judgment in the present case.
Your Honor, it is not the position of the council that there may not be evolution of the law, considering as the bench has itself recognized that the Constitution is a living document. But at the same time, Your Honor, it would be our submission that the evolution of law cannot be going against certain fundamental precepts. And in this particular case, it would be our submission that the fundamental precept of Article 30 is the autonomy of minority institutions. Your Honor, this very autonomy allows several institutions to have reservations for their own community, such as, for instance, the 50% reservation in the St. Stephen's College, and there was also a move for 50% reservation in Aligarh Muslim University. In that case, it would be our submission that imposing the requirements of affirmative action might be inconsistent with that minority autonomy that is recognized as fundamental in Article 30.
No, in the present case, if you see fact sheet, there is no such thing, where 50% reservation is challenged.
But at the same time, Your Honor, even if we see, for instance, the example that was advanced by the bench with respect to the RT Act, now the several authors and several scholars have actually cited that the judgment itself has to be reconsidered, as the bench itself pointed out. Because the question in that case was again with respect to reservation, and the court ended up saying that the entire act should be exempted when it comes to the application to minority institutions. So therefore, it would be our submission that at least with respect to reservations, there should be autonomy, but the general standard setting, for instance in the RT Act, should be something that can be applicable to minority education institutions as is consistent with TLA Foundation.
Okay, one question before you proceed. When there is a clash of two fundamental rights, like for example Article 15 of Indian Constitution vis-a-vis Article 30 of Indian Constitution, and also Article 21 of Indian Constitution vis-a-vis Article 30 of Indian Constitution. Kindly answer this question. Which one will prevail?
In that, I'm sorry?
Which one will prevail?
I couldn't have. Sorry?
In the event, yeah, okay. Which one will prevail in the event of clash between two fundamental rights? One is Article 15 vis-a-vis Article 30, and the second one Article 21 vis-a-vis Article 30. 21 because right to education as a fundamental right. 15 because non-discrimination on the grounds of religion, caste, creed and all that.
Your Honor, in the case of conflict between fundamental rights, we are to look at doctrines such as the doctrine of double proportionality that has been advanced, for instance, in the case of Association of Democratic Reforms versus Union of India. So, in that case, we have to look at which particular act is legal, which is necessary, and also the fact that which would lead to least intrusive action in the fundamental rights. It would be our submission. And another query in that same test is also about whether there are any less intrusive means of doing so. It would be our submission.
Okay, counsel, this takes me to very extremely important question, which I think this court must pose to you to have a fairness in this regard. Counsel, although the fundamental rights are not given in sequence, there is a sequence that one may form, and the sequence has been formed from time to time, right? So, Article 25, I hope you agree that Article 30 is in continuation of philosophy of Article 25 of Indian Constitution. You agree with this or not? You answer this first question. Do you agree that Article 30 is in continuation of the philosophy that is given in Article 25 of Indian Constitution? Do you agree with this?
Indeed, Your Honor.
Okay.
Substantively give rights to my body.
Okay. So, counsel, Article 25 and then subsequent articles of Indian Constitution are the only fundamental rights which begins with reasonable restriction first and then ends with the right. Whereas all other fundamental rights, they begin with the right first and then end up with the restriction. So do you not consider that these fundamental rights comes in the end in the philosophy of fundamental rights and will not have way when it comes to other fundamental rights? Do you agree with this?
Your Honor, from the Council's limited understanding, it would be our submission that certain rights do get predominance, because as is also whenever the court makes an inquiry about the basic structure, then certain rights do receive predominance, and Article 25 is one of those rights. And therefore, Article 30 is an extension for minorities to be able to substantially enjoy the right to freedom of religion. And to also promote their culture and also to for the benefit of their own communities. We have Article 30 as an extension of it.
Okay, you may proceed.
If the question was correct.
You may proceed. You may conclude.
Your Honor, noting my time. I'm sorry. Your Honor.
You may conclude.
Much obliged, Your Honor. So, just to conclude, Your Honor, it would be our primary submission that private universities such as Dr. Paul University may have been established under a State Private Universities Act, but the act of statutory incorporation is not determinative. What is determinative is that it is sponsored by a minority body that has substantially established that particular institution, and therefore they are entitled to protection under Article 30, and that such institutions should be able to get equal protection at par with other state laws in recognition of their minority character. And holding anything otherwise would go against the objectives of Article 30. Unless there are any further questions, the Council would like to call upon his co-counsel to address the third and the fourth issues. It was an honor arguing before this court.
Please.
May it please this Honorable Court, I am speaker number 2, appearing on behalf of the petitioners. I shall be addressing issue 3 regarding the validity of the JDU Amendment Act of to Speedy Justice in the present matter. At the very outset, it is respectfully submitted that, first, the JDU Amendment Act of 1981 is a valid legislative exercise, removing the basis of the 1967 judgment. And second, the demand by the larger bench violates the fundamental right to speedy justice under Article 21. Your Honor, before I proceed with my arguments, please let me know if my audio is stopping or if there's a pause in my voice so that I can repeat the argument for your sake. This amendment does not seek to, beginning with issue 3, it is respectfully submitted that the JDU Amendment Act of 1981 is a valid exercise of legislative power. This amendment does not seek to alter historical facts, but rather clarifies the character of the institution considerations in light of its origin and removes the basis of the 1967 judgment. Your Honor, at the very outset, the respondent's contention that the amendment impermissibly changes facts is misplaced. I invite the attention of Your Honors to para 8 of the Moot proposition, wherein it is stated that, and I read for your convenience, the apex court denied the right to administer JDU in accordance with Article 30, Clause 1, as it was established by the legislature. From this statement, Your Honor, it can be inferred that the 1967 judgment proceeded on the premise that statutory incorporation is determinative of establishment, and therefore concluded that the university could not be said to have been established by the Pershi community. This was not a finding of a historical fact, but rather a legal inference drawn from statutory framework. The 1981 amendment does not purport to write history, Your Honor. The factual position remains unchanged. The Adarsh Anglo College, which was founded by the...
No, counsel, you're wrong. Factual position doesn't remain the same. There is a slight change. Can you please answer under which subject, under which entry this education subject falls?
Your Honor, education is a part of the concurrent list of schedules.
Concurrent list. So in the present matter, as opposed to JDU case, in the present matter, the act was passed by 2 state governments. And you are relying on JDU Amendment Act 1981, which was passed by the central legislature, that is Parliament. So you cannot justify, you cannot question state legislature, action of state legislature on the basis of what was done by the central legislature. I'll give an example. 3 states in India, in the present legal system, they passed, without there being a central legislation, a law on Hindu Hindu daughters' right to co-personary property right that they have given before central government stepped in. Right, so it is within the power of state governments to legislate simultaneously on the same subject. So facts are not same. Please do not misguide. Do not try to twist the facts.
Your Honor, just to clarify, this issue is pertaining to the JDU Amendment Act of 1981, and it is not relevant to the Paul University facts, which again are governed by the Shastra Private Universities Act of 2023. Those 2 issues are entirely distinct, Your Honor. If I may proceed with the argument.
Counsel, look at the memorial first page. Please look at. See,
Right, Your Honor.
Union of Indus versus State of Shastra. And the apex and the present apex court clubbed all these cases together, given the constitutional question that is involved, and constitutional question remains the same, although facts might be different. So you cannot make a segregation of cases when this court has collated all these cases. You cannot discuss these things in isolation, when a constitutional question remains the same.
Your Honor, just to clarify, issue number 3 is whether the JDU Amendment Act of 1981 is constitutionally valid to supersede a judicial decision of the apex court. Over here, the council is trying to establish that the 1981 Amendment Act is a valid exercise of legislative power and does not seek to supersede the 1967 judgment of the Supreme Court.
But counsel, okay, I agree, counsel. But then this court is a guardian of fundamental rights. This court is a guardian of Indian Constitution, and it appears that the present Amendment Act is passed not keeping in view the provisions of Indian Constitution, but by keeping in view the sentiments of people. And this court doesn't accept that such law making should happen in the legal system like constitutional democracy, like in this Indus, where laws are being passed keeping in view the pressure from the people. Laws should be passed keeping in view the constitutional principles. So we still would like to challenge this act. If I may draw analogy in this regard, if you remember, counsel, Daniel Latifi versus Union of India, the stand taken by the Supreme Court, which post Shahbano case, there was a legislation which was passed, Muslim Women Protection of Rights on Divorce Act 1986. This act was passed as a response to Muhammad Ahmad Khan versus Shahbano Begum case. Immediately this act got challenged in Daniel Latifi versus Union of India. So Daniel Latifi versus Union of India, although Supreme Court did not struck this act as unconstitutional, but they found a golden meal, and the constitutional balance they found. So similarly, this apex court feels that this act can still be discussed from the point of view of striking a balance in the society.
Your Honor, if I may also draw an analogy, there are several other minority education education institutions. Let's take the example of the Ira University, which is located in the Uttar Pradesh. Now, the Ira University Act of 2016, passed by the Uttar Pradesh legislature, expressly recognizes the Muslim minority trust as a sponsoring body and vested with significant governance powers. Similarly, the T. Thankar Mahavir University Act of 2008 explicitly recognizes the Jain minority university and the Jain sponsoring trust as the sponsoring body of the university. Your Honor, in the present case, the Ardeshir Anglo University, which was established by the Pershi community and later incorporated into the Jijiboy Gulabji University, the legislating act did not explicitly recognize the contribution of the Pershi community towards the foundation of this institution. Therefore, this amendment was simply brought in to recognize the efforts of the Pershi community and the efforts of Jijiboy Gulabji in establishing this university, Your Honor. If I proceed with the arguments, Your Honor.
Yes, please.
Much obliged, Your Honor. Your Honor, the respondents contend that such incorporation amounts to a surrender of the institution's minority identity and rights. However, the submission is untenable. As observed by this Honorable Court in Aligarh Muslim University versus Naresh Agarwal, there existed no fundamental rights prior to the Constitution coming into force. Thus, the question of any surrender of rights during the pre-constitutional period does not arise. The British Indian government functioned as a sovereign imperial authority, and educational institutions were not recognized as universities and did not have the power to grant degrees unless they were incorporated through a statute. Thus, the incorporation was necessary for JDU to be able to grant degrees to its students and cannot be characterized as a voluntary relinquishment of minority rights. In this context, the 1981 amendment merely corrects the legal characterization of the incorporation process by recognizing that the statutory incorporation does not negate the minority nature of the institution when the origin, the purpose, and the foundational initiative lies with the minority community. Your Honor, this is consistent with the judgments of Tirath Ram Rajendranath versus State of UP and Shri Prithvi Cotton Mills versus Brochborough Municipality, wherein this Honorable Supreme Court had held that, and I quote, "This court has pointed out in several cases the distinction between encroachment on the judicial power and the nullification of the effect of a judicial decision by changing the law retrospectively. The former, which is encroachment on judicial power, is outside the competence of the legislature, but the latter is within its permissible limits. In the present case, the amendment merely removes the earlier premise that incorporation is equal to state establishment, and thereby aligns the statutory provision with the constitutional understanding of Article 30. Importantly, Your Honor, the addition of the statement established by the Pershis of Indus through this amendment is also consistent with legislative practice in Indus concerning minority universities. Your Honor, although this amendment was brought in at a time when the social sentiments were running heated, however, this is only brought in to ensure consistency with other legislative practice. As I have already cited examples of Ira University, T. Thankar University, there's also examples of Integral University and Sam Higginbottom University. These statutes do not create a minority character. Rather, they acknowledge and identify the role of the minority community in the establishment and the administration of the institution. Seen in this context, Your Honor, the 1981 amendment to the JDU Act is neither anomalous nor unconstitutional. It follows an established legislative approach of formally recognizing the contribution and the foundational role of a minority community in an educational institution, particularly where such recognition has constitutional implications under Article 30. Additionally, Your Honor, it is submitted that the present challenge by the respondents is fundamentally untenable on the grounds of institutional inconsistency. Your Honor, the JDU Amendment Act of 1981 is a statute duly enacted by the Parliament in exercise of its legislative competence. As its Honorable Court recognized in R.K. Garg versus Union of India, every statute carries a strong presumption of constitutionality, and the burden lies squarely on the challenger to demonstrate a clear constitutional infirmity. In the present case, the respondents, who are representing the Union of Indus and the state of Shastra, as rightly pointed out by Your Honor, seek to question the validity of a law enacted through the very constitutional processes that are entrusted to uphold. It is submitted that a state cannot do hot and cold in the matters of legislation. exercise its legislative authority to enact a statute, the state cannot, merely on account of subsequent change in policy or governmental regime, turn around and challenge the validity of that very enactment. Such a challenge undermines the stability and predictability of statutory framework. These are values that lie at the heart of constitutional governance, Your Honour. Therefore, it is submitted that the JDU Amendment Act of 1981 does not alter historical facts, but instead clarifies the legal significance and removes the erroneous basis of the earlier judgment, and is therefore a valid exercise of legislative power. Council seeks permission to proceed to issue 4 concerning the right to speedy justice.
Please.
Much obliged, Your Honour. It is respectfully submitted that the demand of the present matter by the larger bench to a regular bench for factual determination violates the fundamental right to speedy justice under Article 21. Your Honour, this Honourable Court in Kusanara Khatun vs. State of Bihar and A.R. Antulev vs. R.S. Nair had unequivocally recognized that the right to speedy justice is an integral part of...
Counsel, you are venturing in an altogether different track. The principle of speedy justice is mostly followed in criminal administration of justice and not in the constitutional advocacy. This is the matter of constitutional advocacy, and you cannot apply Kusanara Khatun versus Sunil Batra versus Delhi administration. Neither Antule.
Right, Your Honour. Your Honour, the Council has cited these judgments just to state that under Article 21...
1 minute.
Just
one
one
minute.
minute. Can you hear me?
Yes, ma'am.
So you just tell me you are speaking of speedy justice, but for attaining finality, whether it is not necessary to get the adjudication by a larger bench. It is not just for the purpose of academics, but it is for the purpose of taking multiple views from the bench, right? Considering several laws. So how does it affect speedy justice? Because you may never know, just reference to a larger bench or remanding the matter does not necessarily mean protracting the litigation or adjudication. What do you say?
Ma'am, Your Honour, I completely agree as you have pointed out. However, I'd like to state that a delay in adjudicating minority status has serious consequences. If I may bring up an instance, if a minority educational institution is being denied of its recognition due to prolonged litigation, it would be compelled to follow general admission norms, thereby losing its ability to prioritize students from its own community. Your Honour, by the time this dispute would finally be resolved by reference to a larger bench, entire batches of students would have passed through the institution without having claimed the benefits of Article 30 protection, which is a constitutional injury that is irreversible. Therefore, which is why it's simply the submission of the petitioners that perhaps this case can be considered on a priority basis, Your Honour.
A simpliciter remanding or reverting a matter to the larger bench or to the original jurisdiction by itself does not protract the proceedings, right?
Right, Your Honour.
And your prayer for speedy justice can always be considered because the court is conscious of the interest of the students. It's not only, it does not pertain only to institution. Okay, a last question from me. The protection to minority institutions is only in respect of administration, rather foundation and administration, or in the services that are imparted also to the category of beneficiaries is what I mean to say. Should it be restricted only to minorities, and would it not default the protection under section 14 of the Constitution in an educational institution? It would invalidate. What do you say? Is it only foundation and administration or the services provided also?
Your Honour, first the Council seeks a short extension of a minute to answer this question and to go over my prayer for relief, as I've run out of time.
Yes, you may take a minute.
Much obliged, ma'am. Your Honour, I couldn't hear what you said. Could you please repeat?
Yes, yes. You answer the query, please. You answer the query.
Certainly, Your Honor. Your Honor, substantial equality demands minority rights. Two communities which are not equally placed cannot receive equal treatment. If minorities are accorded equal treatment as a majority or the general category, it would in itself amount to discrimination against them. This is a fundamental tenet of Article 14, Your Honor. Your Honor, under Article 30, minorities are granted the right to administer and establish minority institutions. Now, subsequent judgments such as the Pi Foundation as well as PA Inamdar have read this article to interpret that certain regulations or standards can be imposed within the services being administered by these universities to ensure uniformity within the education being provided or to ensure that certain standards are being maintained, to ensure that malpractices are not being carried out in the administration. However, in regulating these matters, the minorities' autonomy should not be curtailed. This is a submission, Your Honor. If your question is answered, can I proceed to the prayer for relief?
Counsel, as far as prayer clause 4 is concerned, are you going to press it for right to speedy justice is going to be affected? Because honorable ladyship has already clarified our mind. So are you going to press it or not?
Your Honor, perhaps the Council can concede upon that point and request for priority consideration of this case due to the severe impact it is having upon the education of minority communities from the Catechist community as well as various other minority communities in the state of Shastra, Your Honor.
See, honorable ladyship is saying that the liberty is always there to approach to the registry and get it listed to the larger bench. It will be better for you that the 7 or 5 honorable judges will reconsider the same things rather than going by 3 of us.
Your Honor, just to clarify, within this issue number 4 of the proposition, it is stated that remand by this matter by your bench to a smaller regular bench for fact finding would be a violation of the right to speedy justice. Even if this matter were to be taken up by a larger bench, they would decide upon the questions of law and would eventually remand it to a regular bench for fact finding. What we're requesting in this issue is for this court to exercise its power under Article 32, leverage its plenary jurisdiction to avoid unnecessary remand, particularly in our case, which involves long pending constitutional disputes. Your Honor, this is not without precedent. For example, in the landmark decision of Indra Sahni versus Union of India, this honorable court had engaged with factual matrices while deciding the constitutional validity of reservations for other backward castes. Therefore, Your Honor, since the record of facts is complete and the issue directly concerns the enforcement of fundamental right, this honorable court is requested to proceed to decide upon both the law and the fact to ensure complete and effective justice. Counsel seeks permission to proceed to the prayer for relief, Your Honor.
ठीक है.
We have perused your prayer. Unless you want to have special prayer, anything special you want to be addressed. By the way, just one query was there in my mind that I should ask you. You said Article 32 enables this court, to intervene and provide a special relief to you. Is it Article 32? Counsel, do you really think it's Article 32?
Your Honor, many apologies. It would be Article 142.
No, one apology only, not many. We don't want many. Only one apology only. So which article then? Which article then?
Your Honor, the Council relies upon Article 142 to do complete justice in a...
Yes. Okay.
One apology to the court, Your Honor.
Okay, thank you.
And there is no special prayer that is sought by the Council.
Yes.
However, with respect to prayer number 4, the Council is willing to concede that...
So cite legal provisions very carefully, Counsel.
Right, Your Honor. It was a pleasure arguing before this court.
Thank you.
Okay, thank you. Same here.
We would like the respondent to start with the argument.
Council number 1. May it please the Honorable Court, my Lord. This is Council number 1, appearing on behalf of the respondents in the matter of Dr. Paul University and Colors versus State of Indus Matter. My Lord, I as Council number 1 shall be addressing issue number 1 and 2, while my learned co-counsel shall be addressing issue number 3. My Lord, now Council shall proceed with their submissions. My Lord, our first issue is whether private universities sponsored by minorities and established under the State Private Universities Act before or after the commencement of the Constitution of Indus can claim the right under Article 30 Clause 1 of the Indus Constitution. My Lord, the respondent submits that they cannot, and we advance two independent grounds to establish that claim. My Lord, the first is that only mere sponsorship does not amount to establishment. My Lord.
Council, can I interrupt? Can I interrupt, Council?
Yes, my Lord.
Come to the memorial page. Who is memorial page? Head page. Head page, you please come to. This present matter is between whom? Present matter is between whom?
My Lordship, the matter is between JU versus Nitesh Mohta.
Who is Nilesh Mohta? Nitesh Mohta? Who is Mr. Nitesh Mohta?
Nitesh Mohta is the respondent, my Lordship, who has challenged the amendment of 1981 that the universities, JU University, will be regarded as a minority institution under Article 30 Clause 1.
What about locus in the present case? Locus standi.
My Lordship, the rights of the my Lordship, the issue 1 and 2 concerns the state of Shastra. So I am as a respondent dealing with the issue 1 as the state of Shastra, and issue 1 is particularly with regards to the private universities. And private universities' rights are being violated, are not being violated here. That is what we as respondent contains here.
No, my learned brother judge said कि what is the locus, and further challenge the locus and how you get affected. That is what my further question is.
My Lordship, our submission would be that we are not being affected by.
I'll just make the question simple. The first question is, are you challenging the locus of the petitioners?
Yes, my Lordship. Shall I proceed with the submission?
So which issue you have challenged? Simply saying yes, the task is not complete.
Madam's question will be answered first.
Okay, you proceed. You proceed for time being.
My Lordship. My Lordship, our first issue is that, our first contention is that mere sponsorship does not amount to establishment, and Article 30 under Article 30 Clause 1.
Council, just a minute. Honorable Ladyship has asked you, are you going to challenging the locus of the petitioner or not? If yes, on what grounds? If no, then what are the reasons for it? You simply answered first Honorable Ladyship's question.
Your Lordship, the petitioners are saying that the statute is valid, whereas as respondent we are saying that the statute is not invalid. Your Lordship, we are challenging the locus standi of the petitioners as they have challenged the amendment. They have challenged the amendment or the judgment of the fixed court that the amendment that they have that they did not.
Council, just a minute. You feel be calm. We are not getting you what you are saying. You may take some 1-2 minutes, or I think someone is sitting in front of you. Researcher or who? Who is there? Researcher. Okay, TK. You may take 1 minute and then you start your argument. First, are you going to challenge the locus? If you want to answer this, you answer. If you want to go by your memorial, you can. Take your time. We are not getting you what you are saying. Have a glass of water then.
I would request silence in the court, please.
My lord, can I speak on behalf of the speaker one in this matter, like the local standard? My lord, the local standard that we are challenging, it will be dealt with in the issue 2. The petitioners, they are claiming that in the Shastras Act, there is no mention of the minorities right as such specifically or explicitly. There is no provision in the Shastras Act, hence they have the local standard. And we are challenging that because just because a law is silent on that matter, that doesn't extinguish your constitutional fundamental right. This is how we are going to challenge the local standard of the petitioners in issue.
I'll just clarify it. Is it the Persian community who is challenged or the educational institution? See the statement of
My lord, can you pardon because the screen net aids for a while.
The Moot proposition, you kindly refer the paragraph number 4 where it has been clarified. Please come to that point. Honorable Ladyship is trying to address that point.
Para number 4, right?
Yes. Yes. So the query is on paragraph number 4. Who has come to the court? Is it the community or the educational institution?
It is the community from the petitioner's side.
So is it a public interest litigation? Is it a public interest litigation?
No, ma'am. No, ma'am.
But this is very relevant questions and very important questions going to the root of the locus. If you are saying that community has come, then why it is not public interest litigation? We will convert it into PIL.
Because there are so many minority committees. There are other minorities also. They may have the same stake. And counsel, counsel, in this same line, I also have another question. Why is it that we are only representing the JDU, only representing the respondent in the context of challenging the Constitutional Amendment Act? Why is it that you are not representing state governments?
My lord, we are representing the state government in the issue 1 and issue 2. And whereas in the issue 3 and 4, we are representing the petition board.
But then that should reflect on the head page, no? And in the memorial page, it is not reflecting. Memorial head page, it is not reflecting.
My lord, it is written as another wherein we have inferred it.
Okay. Yes, please proceed. Now you may proceed.
My lordship, the present issue examines whether mere sponsorship by a minority is sufficient to claim protection under Article 30+1. Our respectful submission is that it is not under Article 30+1 because Article 30+1 demands establishment and not mere sponsorship. And the sponsorship alone can never satisfy the constitutional threshold required to claim minority rights. My as conclusively clarified by the 7th bench in earlier University Justice Naresh Agarwal. These two requirements are conjunctive. The right to administer flows only after the institution is first established by the minority. Therefore, the establishment is not optional and it is a foundational constitutional prerequisite. My lords, the petitioners, this establishment, which has the meaning of establishment, has been clarified in the AMU judgment, which means that the body who actually brings into existence that particular educational institution and cannot be reduced to mere genesis or funding measure. Sponsoring at best is a preparatory or supportive act measure. It is not the constitutional act of founding an institution. My lords, the 7th bench has further clarified that to claim protection under Article 30 Clause 1, an institution must satisfy the real positive indicia. In this regard, this honourable court has also recognized the power to pierce the veil to ascertain the true character of the institution. As held in AP Christian Medical Educational Society versus State of Andhra Pradesh, in that case, the court examined an institution which claimed minority status but was in substance not genuinely established or administered by that particular minority community. The court therefore refused to extend constitutional protection, holding that mere labels or formal claims are insufficient. My lords, therefore, the minority status cannot rest on nomenclature alone. It must be established through real and substantive indicia, demonstrating genuine minority establishment and control. My lords, the real positive indicia test requires 3 elements. First, the minority must play a predominant and near complete role in bringing the institution into existence. This requires an actual and tangible relation, not mere sponsoring. My lords, the second is the purpose of the institution must be predominantly to serve minority interests. And mere financial assistance does not establish that the institution exists for the advancement of the minority community. And the third is the administration must be vested in the minority community. Mere sponsorship or funding does not translate into administrative control. The Constitution requires real and demonstrable control and not a formal or indirect association with law. My lord, the sponsorship fails to satisfy all these 3 essential indicia and it neither proves establishment nor minority purpose nor
Council, there's a query here. If under Article 12, a public authority can be identified on the simply basis of the measures funding and measure sponsorship that is coming from the government, then that institution can be called as public authority. Similarly, under Right to Information Act, a public authority can also be, adjudged as, any institution can be adjudged as public institution where it is financially supported and financially funded by the government. Then why not in the present case where a religious minority institution is completely sponsoring finances for the education institution, why it cannot be declared as a minority institution? Why do we have this objection when state authority can be identified on the basis of finances? Why not minority institutions?
My lord, the minority institution here is only being sponsored by that particular minority community membership. And only sponsoring, only providing the financial support does not establish that your purpose is also to promote that particular minority community. And your the beginning, the origin arises from you only. Because you are just providing the money, the financial criteria that needs to be needs for the staff.
Then what is your idea of sponsorship, council then? Can you please cite your idea of sponsorship on the basis of some judicial precedents?
My lordship, for example, if a society sponsors the minority, but the minority committee comprises more members of majority groups, minority rights can be denied or subsequently cancelled, even when it is granted at the first place, my lordship.
Council, what is your problem? If the particular community is sponsoring their institution, it will reduce the burden of the state. So why are you coming into between? Okay, don't do that.
My lordship, we are not intervening in that case. We are just trying to prove the fact that only sponsoring a particular minority, particular educational institution, it does not establish the criteria that is required to claim right under Article 30.
So then what is criteria? Yes, counsel. So then, to make it very simple, what is criteria then that you think? When you oppose, simply you can't oppose. You have to oppose with some justifications.
Lordship is private educational institution which is being sponsored by the minority community. Their purpose should also be to promote that particular minority community lordship. Merely stating that a minority community is providing the financial assistance does not establish that you are also your aim is also.
Counsel. Let me tell you another substantial thing in this regard. A society has come forward. Yes. Counsel, in the present case, a registered society and a registered public trust under the religious minority has come forward and has established an educational institution. What more evidence you want to call it as a minority education institution? And administration is also going on by the minority educational minority community. What more parameter you want it to be there?
My lordship, it is not mentioned anywhere in the proposition that it is also being administered by the.
No, counsel. Here discussion is not about facts. Here discussion is about law. What do you think is the idea of sponsorship?
Sir, point number 1.1. Point number 1.1, argument advanced.
You may refer point number 1.1 of the proposition.
Third line. Conjunctive reading.
Paragraph 1.
1.1. Conjunctive reading. Argument advanced.
Page number 14. Page number 14 of memorial, you please come. Yes.
Yes, my lordship.
Amidst this counsel, we are throwing one more query to you, which you may have to answer. Under Article 30, Clause 1 of Indian Constitution, is it necessary for state machinery to step in and to establish and to support and to go for incorporation of a university, which can very easily otherwise be done by the community itself? Is there any need to have enactment or incorporation from the side of state machinery under Article 30, Clause 1? Is it necessary, counsel?
No, my lordship, it is not.
Then why it is done in the present case? Why it is done in the present case?
My lordship, only for providing the authority to grant degrees, it is a mandate under Section 20.
No, can't any university established or monitored by a society or recognized by the University Grants Commission, are they not capable of distributing duties? Is it necessary for every university there should be a special act? Is it necessary for every university there should be a special act?
Yes, my lordship. A university is always established under a particular state act. Lordship. That's
State of Shastra, Maharashtra Public Universities Act 2016, right? This act is there. So because it is not necessary that a society may run the university.
Okay, I will come to that.
Council, I will help you. Just refer to why secularism. This is something which the petitioners have missed. But the whole purpose of establishing a minority institution is to achieve the goal of secularism, which is particular only to the to this country and no other country. Isn't it? So that should be your answer. But you think it is going against you. Therefore, I was trying to help you by saying whether the community has come or the educational institution has come to the court.
Educational
And so that is the thing. Of course, this question is going to be transferred to the petitioners at the end, and let them be prepared for it. So therefore, you should challenge the very locus as to whether it is going to affect only one community or the communities at large, and therefore it cannot be a private litigation, but it should have come in the nature of public interest litigation. So I have answered the question on your behalf, don't worry. Now you start with your arguments.
Much obliged, Your Lordship. Now, my lords, the council is permission to proceed with issue 2. My lord, issue 2 concerns whether private universities sponsored by minority communities established or incorporated by state law can claim equal protection as per with the other state laws in recognition of their minority character. My lords, the Constitution of the Republic of India establishes a federal structure. Under this structure, legislative powers are distributed between the union and the state, and education being a subject in the concurrent list permits significant state involvement. As a result, state legislatures are fully competent to design statutory frameworks suited to their own regional needs and priorities. My lordship, at the same time, the rights of minorities flows directly from the Article 13 of the Constitution, and therefore any state law or even statutory silence must be tested against the constitutional standard under Article 13, and not by comparing it with the provisions of another state statute. In this framework, states retain legislative autonomy to enact different laws as long as they operate within constitutional limits. Therefore, variations in laws across states is not an anomaly, it is an inherent feature of federal government. Furthermore, my lord, since the power to recognize the minority character is already occupied by the NCMEI Act 2004, a state act does not need to replicate these provisions to be constitutionally valid. The 2006 amendment of NCMEI Act included Section 2C, which gives competent authority appointed by the appropriate government to grant no objection certificate for the establishment of any educational institution of their choice by the minority population. Therefore, the state government, as an appropriate government, has designated competent authority to decide on the issue of minority status and grant NOC to minority institutions. Further, as per Section 10 of NCMEI, if the competent authority does not grant such certificate within 90 days or does not communicate on the rejection, it is considered deemed approval, and as per subsection 4 of the same section, the applicant is entitled to commence and proceed with the establishment of a minority educational institution. Therefore, the absence of an express provision relating to minority institutions within a statute does not affect the existence of that right. It only indicates that the statute operates as a regulatory framework, while the determination of minority character remains a constitutional question. My lords, different states may adopt different approaches for regulating private institutions, and each approach are constitutionally permissible, provided no fundamental rights are affected by such an enactment. Therefore, such a model cannot be questioned merely because another state has adopted a different legislative approach. The question does not require uniformity. The Constitution does not require uniformity of statutory design across states. It is equally important to distinguish between constitutional rights and statutory recognition. The rights of minorities to establish and administer educational institutions is a constitutional guarantee law. its existence does not depend upon its reputation in a state statute. My lord, whether an institution qualifies as a minority institution is ultimately a matter of factual determination, depending on who establishes and administers it. Where an institution in fact satisfies these constitutional requirements, it will derive its protection directly from Constitution itself. This inquiry is independent of legislative drafting and cannot be conclusively decided by the presence or absence of statutory language. My lord, if it were to be suggested that every state must adopt identical provisions, it would effectively compel uniform legislation across the country, and this would undermine legislative autonomy in the country, and that will disturb the federal balance envisaged by the Constitution. In conclusion, my lords, the federal structure permits legislative diversity and constitutional rights under Article 50 Clause 1 operate independently of the statutory regulation, and therefore mere variation across state law cannot render a statute constitutionally incumbent. My lords, I now respectfully invite my learned co-counsel to address issue 3 and 4.
Counsel, one query is there. Can you please answer this? Do you consider that by virtue of an enactment establishing or incorporating a minority educational institution, is it within the power of state to recognize a particular university as minority institution?
Yes, my lord. The state is the statute under which that particular university is being established. That university has.
So your argument doesn't stand here. So your argument doesn't stand here that there is no mechanism to establish that in a particular education institution, whether it's a minority institution or not.
Lordship, the state act, it is not a mandatory requirement that the statute under which the institution has been established must contain a protection clause, because their rights have already been protected by the Constitution itself, my lord. That's why it is not a mandatory requirement.
Okay. You counsel may begin.
May it please the Honorable Court, I am appearing as the counsel on behalf of the respondent. My learned co-counsel has addressed issue 1 and 2, and I shall confine my submissions to the issue 3 and issue 4. In the issue 3, on behalf of the respondent, it is humbly submitted that the JDU Amendment Act 1981, this constitution is void on 4 independent grounds. The very first ground is that the Amendment 1981, it overrides a judicial finding of 1967, not the law itself. If the facts can be rewritten, judgment becomes a decision, not a binding decision. The 1981 Act does only one thing, my lords. It declares that JDU shall be deemed to have been established by the pursuit of Indus. It does not amend the law, Article 30 Clause 1. The issue is about the difference between law and the facts. Because every judgment that is delivered by the court of law, it consists of both. Here, the key fact is that the university was created by a statute, as mentioned in the point 5 of the Moot proposition. The legal rule, however, is that only institutions that are both established and run by a minority can claim protection under Article 30 Clause 1.
Counsel, I have a query.
Yes,
My view is, by way of Shastra Private University 23, you wants to control these minority institutions.
my lord,
Indirectly you want to control. Therefore you are opposing.
my lord, can you repeat it?
My question is, by way of this act, Shastra's act, you wants to control the minorities institutions.
No, my lord. My lord, we would like to submit that because this Shastra Act, it is confined to the issue 2 itself, and therein the counsel number 1 has argued that mere silence of the right in the Act does not mean that the right is extinguished. It is a fundamental right that is guaranteed to them by the Constitution.
No, it is their fundamental right also to establish their own institution and run according to their own. Taking over the institutions. Council, Honorable Leadership, has some question.
Please come to your prayer number 3 and 4. I mean 4 and 5. What are you praying for? We understand that remand does not violate the right.
Yes, ma'am.
That prayer is granted. Okay, now justify your next prayer.
Okay. So the fifth prayer in our prayer section is that directing the exercise of the jurisdiction under Article 142 of the Constitution of India, wherein the Supreme Court, in their exercise of the power, can pass any order they deem fit. And wherein we, as the respondent, ask you that the regular bench, it completes the remanded fact-finding proceeding within such mandatory time frame. Under this Article 142, the apex court can fixate the time period wherein the regular bench can do
Just tell us what is the mandatory timing for the court, for constitutional courts? Who prescribes? So there cannot be any mandatory timing, right?
Yes, my lord.
Because
as per your own discretion under Article 142, you can pass an order.
no, but you are also supporting the prayer of remand, isn't it?
Yes, my lord.
So how can we do both the things?
The remand should be granted. The case should be transferred to the regular bench for the fact finding, as there is a factual dispute between the.
Why under Article 142? Why we cannot do the fact finding work?
My lord, because you are
There's
the
no-
larger bench and larger.
Yes.
Larger bench only deals with the question of law. It does not.
No, who said this? Where is it prescribed in this manner that it only deals with law?
My lord, ordinarily when a petition is filed under Article 32.
No, but that is the powers of the court which they know how to exercise. These are the inherent powers under 142, 32. So who will prescribe the time limit?
The larger bench will describe the time limit for the regular bench. It is a division bench. It will consist of 2 judges, which will.
Okay. And that order will again be challenged before the larger bench. So again we will see as to whether the remanded judgment is right or wrong, and why it is right or wrong, again go into fact finding.
Once the fact finding is completed by the regular bench, there can be no dispute of the fact finding. It is the judicial.
Who will impose this restriction?
My lord, which restriction?
That we cannot go into fact finding again. No, it's all right. Yes, yes.
My lord, with your permission and proceed with my argument in issue 3. Yes, please.
You may summarize. You may summarize now.
Yes, my lord. My lord, earlier the court had already held that such a university is not a minority institution. Now the parliament is trying to change this position by saying that it was actually set up by the members of minority community. And this amendment, it was brought forth after there was a public pressure upon the parliament. There was no actual fact finding done upon this. In 1967, when the apex court passed the judgment, it had done the fact finding, wherein it had accepted that fact that 1967 is established by the parliament, and upon that established fact, it applied the legal principle of the Article 30 clause 1, wherein it is stated that only the minority institutions that has established and administer the institution can claim the protection. Hence, the parliament that has brought the amendment in 1981 is in direct contradictory to the fact that was accepted by the court of action by the Parliament, it violates the basic structure, separation of powers and rule of law. By directing that JDU shall be deemed to be established by the minority, Parliament assumed the role of an appellate court over the 1967 judgment without any hearing of the evidence, without any legal reasoning. Such an exercise also strikes at the heart of the rule of law because it undermines the finality and authority of the judicial decision. The rule of law necessarily requires that disputes be conclusively determined by the independent court and that such determinations cannot be placed by legislative order. If this is permissible, then every binding constitutional ruling of this court is hostage to the next parliamentary majority. Ground 3 that the respondent submit in issue 3 is that the legislative incompetency to alter the historical fact. It is an undisputed fact that the JDU was created by the Imperial Legislative Council in 1920. The Ardeshir Anglo College, founded by Mr. G.G. Boy Dorabji, was incorporated into JDU. These are two legally distinct entities. Under the doctrine that was established in the P.A. Inamdar case, minority status is not a movable property right that can be inherited from the predecessor. It is a status that attaches to the specific institution currently claiming the Article 30 protection. The 1981 Act does not cure a legal deficiency, but rather it merely relabels that the already established and accepted fact. And as the petitioners in their oral argument have claimed that the 2024 judgment is supporting their argument, the 2024 judgment does not retrospectively validate the 1981 Act, my lords. This argument is a mix of substance with the method. Even if the substantive outcome of the 1981 Act is correct, the constitutional problem lies in its the method, the substitution of legislative assertion for judicial determination on constitutional questions. That function belongs exclusively to the court. Moreover, validity is assessed at the time of the enactment. My lords, in 1981, the operative law was the 1967 judgment. The 1981 Act defied that operative law and was void when enacted. 2024 overruling operates prospectively, not retrospectively. It cannot reach back to cure what was there on arrival. The 2024 judgment itself proves this. It demonstrates the correct constitutional method for revising a judicial precedent. Parliament bypassed this entire process, upholding the 1981 Act, meaning that they have anticipatorily overruled the apex court's decision. This proposition cannot be accepted, my lord. And with your lordship's permission, I would like to proceed with the issue 4. The issue 4, it deals with the whether the order of remand does it violate the Article 21 or not. On behalf of the respondent, it is submitted that the answer is a no. There is no violation of the Article 21. The right to speedy justice under Article 21. Yes, my lord.
This prayer is granted. You need not emphasize it.
Okay, thank you, my lord. Then, my lord, can we proceed with the prayers?
Yes.
My lord, in the light of this commission's advance, it is most humbly prayed
Just a
that
minute.
this honorable
Just a minute. Come to page number 13. Point number 3.
of the memorial, my lord.
Yes, summary arguments.
Okay.
Fifth line.
My lord.
Such action violates the doctrine of separation of powers, undermines judicial review and the rule of law.
Yes, my lord.
How? Rather, it is my contention that, as Honorable Lordship has stated, the ultimate object for the minority is Article 30 and the fundamental secularism.
Yes, my lord. The separation of power in this argument, wherein it is referred, it refers to the fact that that in 1967, when the apex court had delivered the judgment, it had established and accepted the fact that that the institution is established by an parliament, by an legislative enactment. In 1981, going contradictory to this fact, it violates this separation of power, because in the basic structure doctrine, the separation of power states that there are three legislative organs. The first is judiciary, executive, and legislature. Judiciary's duty is to adjudicate matters on the basis of fact, to interpret the law, whereas the parliament's duty is only to legislate law. It cannot amend the fact that was established and accepted by
Is separation of power part of basic structure?
this power.
In which case it was declared so?
In Keshanand Bharati.
So that means if Parliament enacted some law, and as per, according to your contention, you should not challenge in court of procedure. That's what she means, I think.
Much of it.
No, they can No, sir. All about the petitions.
For the rebuttal round.
For rebuttal.
For rebuttal now, petitioners, you may please come forward.
First, Your Honor. Your Honor, at the outset, if I may just answer the question that was advanced by her ladyship. So, it would be our submission that this is a public interest litigation, and the jurisdiction was given under Article 32, and therefore we consider it to be a public matter because significant matters of constitutional interest are concerned. Your Honor, you not.
Therefore, it cannot be only a single university. Actually, it was for the respondent to challenge your very locus. See your prayer clause. See the prayer clause. You are referring to minorities, communities, right? Yes. But in the body of the petition or in the title, there is no mention that you are appearing on behalf of all the minority communities. So maybe some of the minority communities have accepted it unless it was a public interest litigation.
Your Honor, in this particular case, as the proposition suggests, so there are other minority institutions also, which are similarly situated as Dr. Paul University, and therefore the
But have they come to the court? Have they come to the court?
Indeed, Your Honor, I think that
You have, there is no,
paragraph 14 of the constitution.
just show paragraph 14.
Indeed. So that says that Dr. Paul University, along with other private universities in the state of Shastra, which was sponsored by minorities, have challenged this particular act.
And others has to be specified, right? And others does not mean anyone or everyone, isn't it? Because the prayer clause is all that you have been submitting is about the JDU. In your arguments also, you have not stated that this is going to affect all the minority communities, or it is at the behest of all other minority communities. Isn't it?
Your Honor, in the oral submissions, however, we made general submissions as
Yes.
to the regard of private universities, which are similarly situated as Dr. Paul University also.
Okay.
No, initially, you do not talk about the locus under Article 32, which ideally you should have, started with. Whether you have a locus in the present case or not. Yes, yes.
Will you keep
Yes.
this in mind, Your Honor?
Yes, yes.
If I may just proceed with the rebuttals.
Yes, please.
Much pleasure, Your Honor. Honorable Bench, the respondents in this present case have tried to argue that private universities which are sponsored by minority societies are not minority institutions. Your Honor, the respondents have asserted that the criteria for establishment has not been proved sufficiently. But they are deliberately doing a very limited reading of the word sponsoring. Your Honor, the sponsoring body is statutory vocabulary that means several things. As the Council had earlier submitted, sponsoring is not mere financial support. When a sponsoring body is applying for statutory formalization under the Private Universities Acts of different states, it has to prove several things. It procures the faculty, drafts curriculum, designs the administrative framework, requires land, and they bring the institution into the
Council, it's all right, you are coming in rebuttal. See, you could conclude it in one line that when they register as minority institutions, there are certain requisitions and conditions precedent, right? For establishing. And it is the statutory authorities who approve the status. So where is the question of challenging sponsorship or foundation and administration? That has to come only after the foundation is there, only after administration commences. The approval is always by the statutory authority. This is not a self-declaratory relief, isn't it? You can't just declare yourself as a minority institution. There is always an approval by the government. And there is a supervision whether you are functioning as a minority institution or not. You all are, like, for example, of course you may not know about it. For example, the TET examinations are there. That we may know better. So, certain conditions are applicable to minority institutions also. And the very fact that they are approved by the statutory authority, the question of sponsorship or foundation does not arise. Because they have to disclose it. There cannot be... Yes.
If I may just paint an alternative picture. So, the Council is trying to take the test that has been advanced by the respondent test. They have said that we have to look at who did the idea of the university come from, where is the genesis, who has established it. Now, it is our assumption that because it is the sponsoring society which is bringing in all of these initial criteria, the government and administration is only providing a rubber stamp. They are only seeing whether all of these conditions are fulfilled. The act itself, the statutory formulation, is only a legal vehicle, and the sponsoring authority is the origin, and therefore we should consider a private university sponsored by a minority to be a minority institution. Yes. Furthermore, Your Honor, if I may also make a rebuttal as to issue 2, the respondents have submitted that there may be legislative diversity across states. They agree, but the respondents themselves have admitted that it cannot be inconsistent with the constitutional right. And it is our assumption that in the present case, the Shastra Private Universities Act is contrary to both Article 13 and 14 of the Constitution, because it is violative of Article 30 as it enacts a blanket legislation curtailing the autonomy of minority institutions to establish their own institutions and administer. Furthermore, they are violating a foundational principle of Article 14, right? Because they are treating unlikes as likes. They are treating minority and non-minority institutions.
Council, we got your point. Speaker number 2 wants to speak something, or you will conclude?
Speaker number 2 will just conclude on these issues.
Okay, we got respondents. Do you want to say something to counter this? Respondents?
Yes, my lord. Speaker 1. My lordship, if the criteria of establishment is not met, the competent authority can deny minority status.
if the criteria of establishment is not met, the competent authority can deny minority status on it. Lordship, it is not a violation of Article 30 as education is a concurrent list. Lordship, if and only the criteria, that is the establishment and the administration, which must be there to establish to claim a right under Article 30 clause 1 the Lordship, and which is the establishment part is not being established here by only being sponsored by a minority community. That is our submission.
ठीक है. Honorable Ladyship will conclude the session.
Your Honor, if I can briefly interject with a rebuttal, I'll just take 1 minute of the court's time to point you to page number 17 and 18 of the respondent's written submission, Your Honors. With respect to issue 1.5, the respondents have explicitly agreed and admitted.
Just a minute. Page number 17.
Yeah, 17 and 18 of the written submissions, Your Honor.
Yes.
Issue number 1.5 specifically, Your Honor. In this issue, if I may proceed.
Yes. What is your submission?
Much obliged, Your Honor. Your Honor, in issue 1.5, the respondents are explicitly admitting that the Shastra Act of 2023 does not recognize minority educational institutions at all, and rather than protecting them, it is negating the entire recognition in itself. Your Honor, this is an explicit admission to a violation of the constitutional principle under Article 30. If I may read out their conclusion to this issue, they are stating that accordingly, in the absence of demonstrable minority establishment and in view of the voluntary submission to a statutory framework that neither recognizes nor preserves minority autonomy, the claim to protection under Article 30, Clause 1 of the Constitution of Indus is constitutionally untenable. However, Your Honor, as the leadership had rightly pointed out, Dr. Paul University is a minority established university, and the government had already recognized this status earlier. This new act under 2023 is seeking to erase that minority status, is seeking to infringe upon their autonomy, and is completely violating their right to administer and establish minority institutions, Your Honor. Admission or submission to a statutory framework does not mean that the university cannot challenge the constitutionality of the 2023 Act. That was my rebuttal with respect to the first issue, Your Honor. With respect to issue 3, the respondents are contending that the 1981 Amendment Act has made a determination of constitutional fact. However, Your Honor, the Parliament has only collected the basis of the judgment. As I had earlier stated, the judgment relied on the fact that the statute did not recognize the founding authority of the G.G. Boy Durabji University. However, I have also drawn real-world parallels to various universities, including various...
Tell me the final point, one-liner conclusion. Conclude.
Much obliged, Your Honor. Your Honor, this statute does not seek to establish a constitutional fact. Rather, it simply crystallizes the founding and acknowledges the contribution of the Pershi community towards the establishment of G.G. Boy Durabji University, Your Honor. That was my conclusion with respect to the values, Your Honor.
My Lord, as the respondent from the equity, can I reply to the reporters?
Should we allow them?
One-liner.
Yes.
Just in one sentence.
Okay, my Lord, lastly, as the speaker too have highlighted that they were intending to only change the basis. The case that they relied on, the Prithvi Cotton...
No, tell me about admission. You have admitted as per your memorial. Make your submission on this aspect only. That's it.
Yes, my Lord, I am making my submissions on that itself. The case that the petitioners have relied, the Prithvi Cotton Mills, it says that the Parliament has the power to change the legal basis on which the judgment has been delivered. Here, the legal basis has not been changed. The legal basis was Article 30 Clause 1, wherein it is required that the minority institution needs to be established by a minority and it needs to be administered by the minority same ground that I wanted to state, that as per the rules of the competition, the court masters have stated that the oral submission needs to be made only on the submissions that are made in the memorial. My lord, kindly refer to the memorials of the petitioner in issue 1. They are only dealing with the JDU, which is a public university. And the issue 1, it only deals with the private university. In their oral submissions, they have dealt with the Dr. Paul University, but their written submission and the oral submission have no consensus. It was a pleasant argument.
So we have heard, and best wishes to you all. All four of you have performed very well, and you all have been quite thankful to your researchers also, I believe. So it's quite apparent, but performance-wise, yes, all have expressed properly. That's all. Now we conclude. You can wait for the results.
Thank you.
If I can just ask a short feedback, sir, we can keep in mind for the future. Anything that you notice or any comments.
The government has an aim to intercept.
Lordships as well. And apologies.
Could you come here?
So, I thank you, sir, for allowing me to speak. So, sir, this seems that the question has not been handled at equity. So, they also have a fundamental right to form trusts. And what they are actually doing is that they are destroying, the government is destroying the rights of the beneficiaries totally. So, I only want to say this, that it seems that the government is intent on destroying the entire edifice of trust which has been built over so many years in so many countries. I thank you for giving me an opportunity to speak.
There we may agree with you, but today's courtroom was basically for the assessment of students, and we wanted them to take it seriously, and therefore we were asking them practical questions. That's all. Okay.
Now we'll conclude the session with a thank you note. Good afternoon, everyone. On behalf of MCE Society, aka New Law Academy, Pune, it was a great honor and privilege to propose the vote of thanks for this session of Dr. P.A. Inamdar National Moot Court Competition on the Right of Minority Education Institution 2026. I extend my heartfelt gratitude to our esteemed panel of judges for graciously sparing their valuable time and leading their expertise to this competition. Your insightful observation through provoking questions and constructive feedback have not only evaluated the participants but have also significantly enriched their learning experiences. For budding legal professional, this interaction with such distinguished members for the legal fraternity is both an honor and a legal opportunity for the immense value. Our Honorable Your Honor have reflected the very essence of judicial excellence and have inspired not only the participants but also everyone present here to strive for greater standard of advocacy. I would also like to express a sincere appreciation for the participants and the judges' keen attention and encouragement extended to all teams throughout the proceedings. Once again, I extend a sincere thank you to the honorable judges for their presence and guidance. Thank you.
Thank you so much.
Thank you, sir.
Yes.
Feedbacks to the participants will be given during the valedictory function.
Now time is not there.
I request the participants to exit the meeting.